Hello, government students. This is Mrs. Politsky, and I have notes for Chapter 13, Section 2, Trials. So, when we talk about having trials, we've got to really kind of look at the type of systems that we're in, an adversarial or an inquisitorial kind of trial system. When we look at an adversarial system, we're looking at a trial system that is a contest between opposing sides or adversaries. And this is found in the US. Lawyers, for the most part, can argue their case and present evidence. They can also have witnesses that will support their claims. We have a judge that is going to be impartial. They cannot ask questions of the witnesses. Only people that can ask questions of the witnesses are attorneys or lawyers. A judge, for the most part, and a jury will hear the case. When we look at an inquisitorial system, this is a trial system that seeks truth through examining evidence and investigation. It's a trial system where the judge plays an active role in gathering evidence, questioning witnesses, and conducting a trial. Juries, for the most part, are only used in serious cases. You're not going to find this in the United States. You're going to find this in other countries. So when we look at our system, we are completely an adversarial system, okay, in comparison to the other. So when we have a trial, we've got some different roles that we have to fill. Plaintiffs, defendants, juries, witnesses, prosecutors, defense or public defenders, and our judge. So when we talk about a plaintiff, this is a person who brought a civil suit to court. So if, for example, I get in a car accident that somebody else causes, I would be the plaintiff who is going to sue the person who caused the accident. Okay. In some cases, the plaintiff can be a victim of a crime. So if it is not a civil suit but a criminal suit, they could be the victim. But in some cases, if it's like a capital offense, like a murder, the plaintiff might actually be your government or the state that you come from. So it could be the state of Nebraska versus the person, the defendant who caused this situation to occur. Your defendant is the person against whom the civil or criminal suit is being brought. This is the person that we're going to try to determine guilt or innocence for. The jury, these are citizens who hear evidence and give a verdict. Anyone in Nebraska who has registered to vote or has a driver's license is eligible to be a member of a jury once they hit the age of majority or hit the age of 19. And typically in Nebraska, an individual will probably be called to jury duty about once every 7 to 10 years. Okay, so it does happen quite frequently. If you live in a county that has a very small population, chances are you might get called to jury duty more often than if you live in a highly populated county. Anyway, witnesses, these are people that are called to provide evidence or sworn testimony. A prosecutor, this is an attorney for the government in a criminal case. So a prosecutor would be basically the state of Nebraska versus whoever our person is, our defendant that we are trying. A defense attorney or a public defender, this is a person that is going to represent your defendant. The defendant cannot provide or afford a lawyer for themselves, then a public defender will be appointed for them. Now, I'm going to say this. Sometimes public defenders get appointed that might not have a lot of experience, especially when we talk about criminal cases. In Nebraska, we've had situations where a person would be appointed as a public defender who might have a background not necessarily in criminal law, but they might have a background in, let's say, tax law or something like that. Your judge, this is a person who presides over the trial. They instruct the jury. They determine the sentences that are going to be handed down once this case is taken. All right. Thank you very much.